Judge, I've been waiting all day to talk to you about this because we're already getting a sense of how different this trial will be.
From our end of the world, lawyers, it's a horrible story, but for judicially, in the courtroom, it's fascinating what's going on.
And here's what I've learned from our folks on the ground there. He gave a less than 2-minute statement admitting he was the shooter.
Basically a confession.
And that he went from the wrong side, meaning enlisted or an officer in the military, to the right side, defending the Muslim world and casualties there. And in the courtroom are these victims who he gets to question. So far, he hasn't cross-examined any, but he has the right to do that. Would this trial be any different if it were in a civilian court?
Well, the obligation of the government to prove guilt beyond a reasonable doubt and to a moral certainty is the same in military justice and in civilian justice. The jury has to be unanimous, and the procedures are basically the same. The government goes first, presents its witnesses, and defense counsel cross-examines. The judge is wearing a uniform, the jurors are wearing uniforms, the prosecutor is wearing a uniform. So aside from appearances, it's nearly the same. I mean, all this is still basically governed by the Constitution and by Supreme Court precedent.
There is one difference, though, that I want to ask you about. He can represent himself. He could go pro se in any criminal court, a federal, state, whatever. But I found this statistic. 11 of the 16 death sentences handed down by military juries in the last 30 years have been overturned. That's according to an academic study in court records. No active duty officer or soldier has been executed since 1961. Now, they're looking for the death penalty in this case.
Right. Well, what
about the appeals process?
Well, whatever you think of the death penalty from a moral and legal and constitutional point of view, under the current state of the law, this is a highly appropriate case for the death penalty. They have evidence of planning and plotting and of slaughter of innocents for some stated political purpose. So this clearly fits into the category of a planned, plotted, execution-style murder. It's classic capital murder. The appeals process theoretically can get to the Supreme Court. The Supreme Court rarely hears appeals from the military courts of appeal. If Major Hasan's theory is, by stumbling and mumbling throughout the defense, he's going to avoid the death penalty, I don't know that that will work, though there is some track record for that. He's not going to get sympathy from the jury, but he may get some sort of a response from an appellate court, which will see the glaring opportunities to challenge the government's evidence that were lost by a layperson, meaning a non-lawyer, an intelligent, educated layperson. He's an MD and a psychiatrist, meaning 3 or 4 years of education beyond medical school, but not a lawyer and not familiar with legal procedures.
What defenses are available in a military court? And strategically, could he have decided not to use the lawyers assigned and represent himself because at some point, or has that point passed, that he could claim, I didn't really understand the proceedings, I'm insane?
He has been found sane enough to participate in his own defense. There is no test of sanity for lawyers. So when he's representing himself as a lawyer, there's no independent test of sanity for acting as a lawyer.
Ineffective counsel? Could he argue down the road, I didn't have ineffective counsel because I really didn't know what I was doing?
No. One could make that argument theoretically, but the Supreme Court has ruled clearly that you cannot represent yourself and then claim ineffective assistance of counsel as the excuse. So our viewers understand this. The Constitution requires that you have effective assistance of counsel. A lawyer who knows what the lawyer is doing. But when you choose to represent yourself, you are waiving that right. And that choice must be inquired into by the court to make sure you are mentally competent to waive that right. And the court made that inquiry and made that finding.
I want to ask you one other question. We see in some cases where even if someone's not convicted criminally, they are convicted, in a sense, civilly, where they have to pay damages. Many people are outraged that the victims of this, because it was declared a workplace violence incident and not injury in combat, are not receiving every benefit they should. In fact, many of them are paying for their own continuing medical expenses. He's collected hundreds of thousands of dollars while he's been held pending trial.
Right.
Why aren't those wages garnished? Do these victims have the chance to go against him civilly? He wins financially, they lose.
They do not have a chance to go against him civilly because they're in the military. His wages cannot be garnished because he's innocent until until proven guilty. The determination of this as workplace violence instead of a combat injury, in my view, is a political determination, inappropriately made and unfairly visiting additional misery on these victims who would be entitled to more benefits from the Army if the political people that run the Army had been appropriate and declared this a combat violence. It's another injury. It's a lose-lose all over the place for everybody involved in this trial, and that's just another example of it.
Interesting perspective, Judge. Wow, this is going to be one to watch, even though we don't see much.
Yeah, there'll be plenty for us to talk about. He's going to take the witness stand. Can he give a narrative, or does he have to ask himself questions? If the judge requires the latter, it'll be a long, tedious, and fascinating self-examination.
Let's talk about it again.
You
Thanks.
got it, Jamie. Always a pleasure,
Judge Andrew
Jamie.
Napolitano, you're the best.